Ah, welcome back, friends. When Justin Louis Baldoni was 38 years old, he bought and directed and starred in a movie called It Ends With Us, starring Blake Alanda Brown slash Lively slash she has so many names, I don't know which one to pick. Well, little did Justin know, it was the beginning of the most treacherous, wildest ride he had ever been on.
F around and find out. F around and find out. F around and find out. F around and find out.
Well, hello, beautiful people, and welcome back to another episode of F Around and Find Out. I'm your host, Elsie. So today, the docket was like back to back to back to back. Some nonsense, some serious stuff. I think the first thing we got was this document, which was from Blake's team responding to Kevin Fritz's letter he sent yesterday. And in the beginning, when I started reading the letter, it actually kind of read as though I was saying it felt like Blake's lawyer was kind of jealous that we were saying Kevin Fritz was funny yesterday. So when I was initially reading this, I was like, oh, they're being a little funny here, trying to match Kevin's funny. Then it got really weird and like whiny. So as an initial matter, the wayfarer parties have agreed to extend the deadline for completion of depositions from August 14th to September 30th. The wayfarer parties don't have an issue with that. And I think the judge is going to allow that, which would have obviated the need for the bulk of the motions and oppositions had the wayfarer party simply conferred in good faith on the matter. Notwithstanding this agreement, the wayfarer parties have filed an opposition in order to assert baseless, false, and irrelevant accusations about Ms. Lively, such as that Ms. Lively has failed to diligently engage in discovery and seeks to unnecessarily delay her July 17th deposition. Now, if you're reading this, you're like, why would the wayfarer parties do this? But wait, they have a reason. This false claim just so happens to parrot the sanctionable narrative spun by the wayfarer's lead counsel, Brian Friedman, for months, namely, that Miss Lively is hiding the truth and afraid of being deposed. Brian Friedman is not the only one saying this. Blake Lively's actions continue to show she's hiding the truth and afraid to be deposed. To be clear, all of this is categorically false. Not only has Ms. Lively repeatedly stated that she intends to move forward with her deposition on July 17th, where has she said that? There is literally not one instance where Blake is like, I'm eager to do depositions. She always prefaces that by, oh, I need to see this before. If I see this, then. It is actually the wayfarer parties who, just hours after submitting their position yesterday, sought to take that deposition off the calendar, relying upon a brazen misrepresentation that they were responding to a request that Ms. Lively never made. Which, if you read this motion, again, it's like, well, why would the wayfarer parties lie like that? But don't worry, because right after spewing all of this, the Lively team go ahead and snitch on themselves with their email correspondence. The reality, contrary to the wayfarer party's alternative facts, they think they're funny, is that Miss Lively is ready and eager to sit for a deposition on July 17th, which is why, unlike the majority of the wayfarer party, she substantially completed her document production well in advance of deposition dates. I'm not going to read everything that's down here because quite literally means nothing to me. The only thing I want to know is, remember in the last briefing, in the last motion, when they said Steve Surwitz only submitted 3 documents, now they're saying Steve Surwitz only submitted 2. Which is it? 2 documents or 3 documents? We will never know. So just then, they were talking about how Blake is not trying to run away from the position. She's willing, eager, and ready. But this is an email from the Lively team on July 7th to the Baldoni team where they say, counsel, we write regarding Ms. Lively's upcoming July 17th deposition. Why are you talking to us about it? It's coming up. Just show up. But they want something. As we have emphasized in letter and email on June 11th and June 17th, and during parties meet and confer on June 13th, Ms. Lively's receipt and review of the film footage on which she may rely for her deposition is a necessary precondition to her sitting for a deposition in this matter. So wait, you just said she's not running away, she's ready to sit for her deposition, but in the same breath, you send me an email saying, in order for her to sit for the deposition that she's eager to do, you need to see and review footage. Oh, okay. My bad. In fact, we agreed to a continuance of Ms. Lively's deposition from the originally noticed date of June 23rd to July 17th on the understanding that all footage to be produced in this case, including the footage that may be used or relied on in Ms. Lively's deposition, will be produced by July 1st. Timely production of documents and footage is critical because, as we have repeatedly communicated, Miss Lively will not sit for a deposition more than once. Miss Lively will not sit for a deposition more than once. Miss Lively will not do this. Miss Lively was not SH'd. Miss Lively wouldn't know what the truth sounds like if it smacked her in the face. How about that? The point of this email that I wanted to make sure you guys understood was the fact that they said in the motion they haven't tried to get away with the deposition. They're not trying to run away from it. They're eager, willing, and ready. Then in their emails, they're like, oh, but if we don't get the footage, if we don't feel like we've reviewed it to our satisfaction, she's not sitting for deposition. And forget trying to get her for second deposition. She won't sit for deposition more than once. Who do you think you are, Queen of Sheba? Another thing that hit the docket today, just when I thought I had seen it all and heard it all and nothing could shock me or surprise me, her attorneys dropped this on the docket. And when I saw it at first, I thought it was some sort of mistake, right? Because it said Vin Diesel. And I was like, what does Vin Diesel have to do with the price of cheese? A true and correct copy of the application to, one, compel the deposition of defendant Vin Diesel and sanctions, or two, alternatively, shorten time regarding a notice motion for the same relief publicly filed in Jonasson versus Diesel. I was so confused. So I go to, because I never knew anything about this Vin Diesel situation, right? So I go to look up the Vin Diesel case. Come to find out, Vin Diesel has a case where Brian Friedman was his lawyer. So I'm going to catch you up really quickly on what the case is. If you already knew about it, I apologize for the refresher. If you didn't know, you're welcome. Vin Diesel gets 4 claims dismissed in assistant sexual abuse lawsuit. Diesel got a court to throw out 4 employment discrimination claims against him on Tuesday, but still faces allegations of sexual battery and wrongful termination brought by former assistant. The assistant, Asta Jonasson, I hope that's how you say her name. I apologize if that's not how you say it, sued Diesel in 2023, alleging that he had pinned her against the wall in a hotel suite and masturbated in front of her. The incident allegedly occurred in 2010. Would ordinarily put it beyond the statute of limitations. But in 2023, Governor Gavin Newsom signed the Sexual Abuse and Cover-Up Accountability Act, which revived certain expired claims of sexual assault dating back to 2009. However, in order to bring a lawsuit under the State Fair Employment and Housing Act, a plaintiff must first file an administrative complaint with the Civil Rights Department, the CRD that we know Blake filed. In a ruling on Tuesday, Judge Daniel M. Crowley held that the law extending the statute of limitation did not extend the deadline to file an administrative complaint, which in 2010 was 1 year. Jonasson also filed claims of retaliation, wrongful termination, sexual battery, negligent supervision, and retention and infliction of emotional distress. Not garden variety emotional distress, just regular old emotional distress. None of those allegations carries a requirement to file an administrative complaint, and so they were untouchable by a judge's order. Diesel's lawyer, Brian Friedman, adamantly denied the claims when they were first filed. There is clear evidence which completely refutes the outlandish allegation, he said at the time. He is a defense attorney. Pick whatever job you want in the world. Imagine being mad that a surgeon has completed multiple successful surgeries. Imagine being mad that a teacher is good at teaching his or her kids. Imagine being mad that a race car driver is good at driving race cars. Imagine that. It's literally his job to be a defense attorney. If he was a defense attorney and losing cases left and right, he would have to leave the job. Nobody would hire him. He wouldn't be good at it. Bringing a man who has nothing to do with this case in this way is ridiculous. I don't know. It's icky to me. I feel icky even talking about it because it has nothing to do with this. When I tell you the docket was full, because before we could even finish reading that and everything that dropped, here comes Judge Lyman dropping this order on our laps. And initially when I saw this, I was like, are you kidding me? I'm still feeling, are you kidding me vibes? But I don't like how I feel in general about this. So Judge Lyman has pretty much given an order granting the extensions Blake Lively wants, but he's given the wayfarer parties and the Lively parties a chance for, I think 5 p.m. on the 11th to change his mind about it. We're going to read it very quickly. The Lively parties opposed the motion in part because, remember, they're okay with the September 30th extension. They're just not okay with everything else Lively is trying to get. The wayfarer parties opposed the motion in part. The parties agree on an extension for the positions. The principal difference between the parties appears to relate to the timing of document production. The wayfarer parties object to what they characterize as an extension of production document. The request of Lively, Jones & Jones Works could be read to extend document production, including the service of new document request in August 2025. However, a letter filed by Lively on July 9th, 2025 states that Ms. Lively seeks to require all parties to complete document production by July 25. This accords with the apparent goal of the parties that all deficiencies with respect to document production be identified by August 1st, 2025, and be resolved shortly thereafter so that the positions can be completed by September 30th, 2025. Parties shall show cause by 5 p.m. on July 11th, 2025, why the court should not issue an order as follows. So basically, this is what Judge Lyman plans to do. He's pretty much letting them know, this is what this is what I want to order, unless you can change my mind by 5 p.m. on July 11th. All document production by parties and non-parties shall be completed by July 25th, 2025, which is what Blake wanted. Third-party subpoenas shall require production no later than July 25th, 2025. Motions to compel regarding document production shall be filed no later than August 1st, 2025. The positions shall be completed by September 30th, 2025. All fact discovery shall be completed by September 30th, 2025. And this is so ordered by Louis J. Lyman. So pretty much, I already take this as what he's going to say. He's going to grant these things unless the wayfarer parties can really rebut with something and he's really going to look at that and say, okay, great, I changed my mind. Until then, let's just assume this is what he's going to rule and let's just go with the flow. Okay, yeah, that is it. It was a packed docket today, or what tomorrow is going to look like. But I guess I'll let you know when I know. I appreciate you guys for being here. Thank you so much. Oh, before I forget, guys, we're 20K subscribers. I almost forgot. 20K. Wow. I'm now you know I'm gangster, so I'm not gonna cry. But like I don't have the words, and you know I could talk. There's 20,000 of you in here that think I'm worthy of your time and your comments. And I know there are people who watch and comment and they haven't even thought about subscribing, or they just so like, oh, I'm just gonna find her. I appreciate all of you as well. Wow. Thank you. I appreciate it. Continue to share my videos, continue to like it for me, leave a comment. I love reading you guys' comments. Believe me when I tell you, I read every comment that comes in. It's not lost on me that you guys keep coming back and you keep showing up for me and you keep liking the videos and you keep commenting and you keep subscribing. It's not lost on me at all. I appreciate it more than you ever know. Thank you for being here. Have yourselves a great day. And I hope you all love the intro. If you made it this far in the video, let me know what you thought about my Jane the Virgin intro. And I'll see you guys in the next video. I'll let you know when I'm getting a little emotional, but I'll let you know when we're going to schedule a live so I can talk to you guys and thank you guys and show my gratitude. And wow, I'm appreciative. Thank you so much. Have a good one. I'll see you. Bye-bye.